All right, you guys, happy Wednesday. And this week we dive more into the legal process, the court process, what that looks like. Because although for me it feels normal, I realize not everybody has been in a jury, has been sued, or has had to sue somebody, which is great. But I think you lack a lot of context when you don't have that experience. So this week I wanted to tie into more of the procedural processes that go into court findings and the law. So, for example, in my situation with Jersey College's final appellate brief, they didn't just focus on arbitration. Instead, I found page after page discussing me personally, my credibility, my motives, my lawsuit. Even insinuations about my legal claims is what I observed. So it got me wondering, why? So moving forward, I ask myself, apparently I'm self-serving. Excellent. Turn to chapter 4. When you can't just argue the issue, you frame the person arguing it. So I have to give Jersey College some credit. I enrolled there to learn how to become a nurse, and somehow, years and years later, they're teaching me how to argue like a lawyer. And the tuition on this second degree, apparently it wasn't included in the first. Nobody defended me in the beginning, so I had to learn to defend myself. And their attorneys have incredibly been educational. Every time they find a new way to frame me, call me self serving, I learn a new legal strategy. So great, we're learning how to attack credibility. Say I'm looking for sympathy? Perfect. Today's lesson is framing. Bring up the merits of my lawsuit, and in appeal, you say, isn't about the merits? Oh, now you have my attention. Because the farther you go, the farther I'll go. You read the page, I will find the document. You tell the court who I am, I start asking why you need the court to believe it. So at this point, I don't even get mad when I read their briefs anymore. I already know it's rage bait. That's what it looks like to me. So I start taking notes instead. Because somewhere along the way, Jersey College taught me the most important lesson I never learned in nursing school. Being right doesn't mean a damn thing if you don't know how to prove it. Jersey College taught me how to argue like a lawyer, which is ironic because I don't think that was part of the nursing curriculum. Nobody came to defend me. So today I learned to defend myself and show you how I got there. Welcome back to the nursing investigation. Jersey College taught me how to argue like a lawyer, not because they wanted to, but because nobody came to defend me. So I learned how to defend myself. I learned how to read regulations, how to read contracts, how to find board minutes nobody expected me to find. Others like me, how to compare what somebody says and now what they say or said 5 years ago. How to ask a very simple question. Does this document actually say what you're telling me it says? And somewhere along the way, something else happened. I stopped reading their legal findings like a scared former student, and I started reading them like an opponent. And let me tell you, that changes everything. Because when somebody writes that you're self serving or seeking sympathy, when they question your motives, when they reduce years of your life and hard work and something you feel you did earn into one convenient sentence designed to make you look unreasonable, initially, yeah, it pisses you off. At the least, it pissed me off because I started sitting here thinking that's not what happened. But eventually I realized getting angry at the framing wasn't enough. I had to understand why they framed it that way. What do they need the judge to believe about me? Why use that word? Why tell that part of the story first? Why repeat this fact, but leave that context out 3 pages later? Why are they suddenly discussing my character when I thought we were discussing arbitration? And that's when Jersey College accidentally gave me the most valuable lessons I've ever learned. The facts do not present themselves. Somebody presents them. Somebody organizes them, somebody frames them, and somebody decides what story those facts are supposed to tell. So fine, you want to frame me? I'll learn framing too. You want to dig through my history? I'll dig through yours. You want to quote the record? I'll read the entire record. That's how this nursing school dispute somehow taught me how lawyers argue. Not how to yell louder, not how to twist facts, how to find the evidence, understand the argument being made around it, anticipate the response, and build a case strong enough to survive somebody whose entire job is to tear it apart. So today, we're doing something a little different. You already know how to find a receipt, but can you present it? Can you defend it? Can you explain why it matters? Can you make somebody who wasn't there understand what happened? And the hardest question of all, can you make them believe you? Welcome back to the nursing investigation. Okay, you found the evidence. Now make me believe you. Apparently, having the receipts is enough nowadays. You found the screenshot, case closed. You found the document, obviously you're right. You found a Google search, a medical record, a text message. You can reenact it with Barbies. Congratulations, you've solved the entire case. Except not really. And if the Lindsay Clancy trial taught us anything, it should be that finding evidence is the easy part. The prosecution had evidence, the defense had evidence, they interviewed witnesses, they brought in doctors, they brought in experts. They had medical records, search histories, text messages, timelines. They could put the exact same piece of evidence on a screen and tell you two completely different things about what it means. And here's the uncomfortable part. They can make it sound convincing. So maybe the question isn't, can you investigate? Maybe it's, can you present what you found? Can you defend it? Can you explain why it matters? Can you anticipate the argument against it? And ultimately, can you make somebody else believe you? Because you already have every receipt in the world. And those still lose arguments. And I know that firsthand. First, investigating isn't proving anything. So let's start with the easiest mistake people make. Finding something that supports your theory does not prove your theory. I think you should listen to that again. Since we're on YouTube, rewind it, because that took a lot for me to learn too. This is where the internet loses me. We decide what happened, then we go looking for things that prove we're right. That's not investigating. That's collecting evidence for a conclusion you've already made. A better investigation always starts with a question. Then you find the source, verify the source, find the context, and here's the part nobody likes, so they don't do it. Try to prove yourself wrong. If I think a nursing school violated a regulation, for example, hypothetically speaking, I shouldn't only research for that regulation. That helps me. I should search for the exception, the amendment, the effective date, the case interpreting it differently, the argument Jersey College is going to make against me, for example. Because if I don't find the weakness in my argument, their lawyers will first. And here's the Lindsay Clancy problem. This is exactly what fascinated me about the Lindsay Clancy case to even begin with. We spent weeks looking at evidence. A Google search happens. Okay, like what does that mean? The prosecution may say, oh, it proves planning. But look at that context. A statement is made, the prosecution interprets it one way, the defense interprets it a completely another. An expert looks at the medical records and reaches a conclusion. Another expert may disagree. And suddenly you realize the evidence didn't change. The argument surrounding it did. That's when something clicked for me. Evidence doesn't come with instructions. It doesn't walk into court and say, hi, I'm Exhibit 47, and here's exactly what I prove. Somebody has to connect it to that conclusion. And the connection, evidence is not an argument. That's the simplest way I can explain it. Evidence, reasoning, conclusion, those are three separate things. If I show you a document, I have shown you a document. That is it. I haven't necessarily proven my conclusion. I still have to explain, why does this matter? What does it establish? How it connects to everything else? And what is the other side saying about it? What will they say? Because if your argument collapses the second somebody gives another explanation for your evidence, you didn't prove a very good argument. And then again, I go back to my own case and I read it differently. This is where things got really interesting for me. After watching the Lindsay Clancy trial, I went back to my own litigation. And suddenly, I wasn't reading the briefs like the person being written about. I was reading them like an investigator. And let me tell you, it was a completely different experience. Because I know what happened to me. I lived it. But a judge didn't. An attorney didn't. So what does the judge get? Someone who was never there? How can you make them feel like they were? Documents, dates, contracts, transcripts, regulations, and two groups of attorneys saying, here's what all this means. Does it sound familiar? Same fact, different framing. So here's a perfect example. I attempted Jersey College's comprehensive exam 4 times. That's a fact. I'm not arguing about that. But watch what happens when we frame it. One version is, she failed a required examination 4 times. Okay, now here's another. She completed the Board of Nursing's required curriculum to sit for her NCLEX, but after she completed her curriculum, Jersey College had her take 4 attempts at a comprehensive predictor examination that became the barrier to graduation and that licensure certification. Same 4 attempts, but those sentences ask you to understand those attempts differently. It gives context. So what are we actually fighting about? Not necessarily whether the event happened. We're fighting about, what does it mean? And lawyers are exceptionally good at fighting over meaning. So rule 1, control the question. This may be the biggest thing I've learned. If you let somebody else define the question, you can spend the entire argument defending yourself inside their version of the story. If you ask me, did you fail the exit exam 4 times? I'll say yes. Congratulations, you got me. Roll the credits, show the scores, repeat it till you're blue in the face. But that's not the question I'm really asking the court. My questions concern what the examination was, how it was implemented, how it was equally fair to all the students, how I was prepared for it, how it was prevented, how I found out about this exit examination, why it was even there, who approved it, what's the significance, and what I completed versus what happened after I completed everything necessary to sit for the NCLEX. Again, context. So when somebody seems to be absolutely destroying an argument, just stop. Listen to the question they're answering, not the question they're being asked. Because sometimes they're winning an argument that nobody actually made. Rule 2, frame the fact. Lawyers don't just give you information. They give you a lens to which to look at that information. Consider Lindsay Clancy. If I introduce you to her as, let's say, a mother who killed her 3 children, your brain begins building one picture. If I introduced her as a labor and delivery nurse experiencing severe psychiatric symptoms, your brain begins building another. Neither introduction by itself tells you everything necessary to decide her criminal responsibility, but both have already changed the way you're looking at her. That's framing, and we're all susceptible to it. Rule 3, anchor first. First impressions matter. Tell me someone failed 4 times a comprehensive exit exam in nursing school before telling me what they completed. You've created an anchor. Tell me Lindsay was searching for something suspicious before explaining the surrounding medical history. Again, an anchor. Start with her psychiatric deterioration. Anchor. This doesn't mean the information is false. That's what makes framing so powerful. The information can be completely real, but the question is, why was this information given to you first? Rule 4, watch what gets repeated. Then there's repetition. One characterization appears, then again, then again. Eventually, the language becomes familiar. This is intentional. Familiar ideas can start feeling established even when the underlying proposition is still disputed. This is psychological. So when I'm investigating something, I ask, did I just learn this 3 times? Or did I hear the same claim 3 times? Those are not the same things. Rule 5, watch what's missing. This one might even be one of the more important chapters or pillars here. Persuasion isn't only about what someone shows you. Sometimes it's about what they don't. You can't put every document ever created into a appellate brief. I've had to learn this the hard way. I want to tell everybody everything so they can understand the full picture. But the Lindsay Clancy case, I go back to and I say, okay, well, you can't call every human being who ever met Lindsay Clancy to the stand. Choices have been made. So I ask, why is this document? Why is this quote? Why is this witness? Why is this paragraph? And what would I want to see before accepting the conclusion I'm being asked to reach? Rule 6, stop being afraid to concede. The internet is a culprit for this. They are terrible for it. People think admitting one fact means they've lost. Lawyers don't always argue like that. Sometimes the strongest thing you can say is yes. So it's so funny when I see people being cross-examined and they're so scared to agree with the opposing party. But sometimes it's much simpler to just be like, yes, that happened. Now let me explain why it doesn't answer the question that we're actually deciding. I took the examination 4 times, for example. Yes, I absolutely did. I've never denied that. Why would I destroy my own credibility pretending otherwise? That is a part of the story. The argument is over what those attempts legally and contractually meant, why they were in place. Why was there 4? Why was it not infinite amount of times? Why was it not only one chance? What kinds of chances were they? Under what kind of pressure was I in to even take those? Was I ever prepared for them? Don't waste credibility fighting the fact you can't win. Fight over its significance. So that brings me to rule 7. Argue against yourself. This is the most important one of all. Before I publish any type of video on my investigation, I now ask another question. If I were the other side, how would I destroy this? Not the dumbest argument made against me, but the best one. If I were prosecuting Lindsay Clancy, what would bother me about the defense's theory? If I were defending Lindsay Clancy, what would bother me about the prosecution's theory? If I represented Jersey College, what would I say about Clarissa Price? And that was uncomfortable, but I needed to ask that question so I could prepare myself for what was coming. Because sometimes the other side has a point, It just has no context. That doesn't mean they win. It means your argument has to survive their strongest point. So we're not going to waste time throwing spaghetti at a wall to see which one sticks. If you can only win by pretending the other side has absolutely nothing, you're probably not ready to make the argument at all. So when the argument becomes about the person, it brings me to something I noticed in my own appellate case as I'm watching the Lindsay Clancy trial. I expected Jersey College's appellate brief to focus heavily on arbitration, since that's what they appealed for. It wasn't about the merits anymore. My case is moving along. Now they want to argue who should hear it. So instead, I recently found myself reading portions discussing me, my motives, my claims, my credibility. Not so much about arbitration anymore. Characterizations that suggest my arguments were self-serving or designed to elicit sympathy. And initially, of course, I took that personally. I'm a human. I didn't go to law school. This isn't an average human experience that I've ever seen from anybody that I could ask anybody how to relate to this or what they did or how I deal with this. They're talking about me. But then I stopped and I asked the question I've been teaching you through this entire video. What is the language trying to accomplish? What is the framework behind it? Not, are they mean? Why don't they care about this? But it's litigation. What does the sentence need the judge to believe? If you describe an argument as emotional, you're potentially asking the reader to contrast emotion and law. If you're describing something as self-serving, you're potentially asking the reader to approach the speaker's account with greater skepticism. If you spend time discussing the weakness of someone's underlying claims, you're telling the reader something about the value of the dispute itself. And that's where I found something interesting. I was like, wait, what are we arguing again? This appeal concerns arbitration. Why are they contributing to character assassination is what it feels like. Jersey College has argued that the underlying merits of my claims aren't the issue being decided in that appeal. So I'm like, okay, fair enough. Then I start noticing discussion about those underlying claims. And instead of immediately saying, they're deflecting, I asked a better question. Why are you doing that? Show me how. If those merits are legally relevant to an issue, show me. That's the argument. But if the merits aren't what the appellate court is deciding, then why does the reader need to know that Jersey College believes my underlying case is weak? What work is that information doing? What framework, what piece in that framework is doing the heavy lifting for them? Because lawyers don't have unlimited pages. Words in appellate briefs are expensive real estate. So when somebody chooses to spend that real estate telling the court something, pay attention. But the most important question above all, and I think this is where the Lindsay Clancy trial and my nursing investigation unexpectedly collided. People watch the Lindsay Clancy trial asking, who's telling the truth? That was their first question. I used to read my own case asking, who's telling the truth? But I started thinking that there's another question we should ask first. What is each side asking me to believe? And how are they getting me there? Look at the evidence. Then look at the bridge between the evidence and the conclusion, because that's where persuasion lives. That's where the framing lives. That's where assumption lives. And sometimes that's where the argument falls apart. So again, you found the receipt. Now what? So yes, investigate. Find the document. Find the original source. Check the date, which I also found interesting. Not everything presented isn't always manipulated. Sometimes it very well can be. So read that whole page instead of the screenshot somebody posted on TikTok. Find the corroboration. Find the legitimacy behind it. Try to prove yourself wrong. But when you're finished, you're only halfway there. Because eventually somebody is going to look at everything you found and say, okay, so what? Your whole argument has been disproven because of XYZ. And that's where the investigation turns into an argument. So why does this matter? What does it prove? What's the strongest explanation against it? Why doesn't that explanation change your conclusion? And can your argument survive someone who desperately wants to prove you wrong? That's the person you need to talk to, not everybody that agrees with you. Because that's the standard I'm trying to hold my nursing investigation to now. Not, can I find something to be so shocking? But also, can I defend what I'm telling you it means? So, all in all, the Lindsay Clancy trial didn't teach me that whoever tells the best story automatically wins. And my lawsuit hasn't taught me that attorneys can simply turn lies into truth. It taught me something more useful. Reality happens once. So we investigate it afterwards. We document it. We remember it. We select pieces of it. We argue about it. And eventually, somebody has to decide what those pieces mean who weren't even there. That's why having the receipts isn't enough. That's why being convinced you're right isn't enough. And frankly, even being right isn't enough if you can't demonstrate why. So the next time somebody presents you with an airtight argument, including me, don't immediately ask, do I believe her? Ask, what is the supporting evidence? What does the evidence actually establish? What has been left out? What was repeated more than once? What would the strongest opposing argument be? And most importantly, did the evidence lead us to the conclusion? Or did we choose the conclusion and then go looking for the evidence? Because anyone can collect receipts and tell a story that does their narrative a service. The harder skill is building an argument that survives somebody else reading them. You found the evidence, now make me believe you. And let's have a constructive conversation. All right, guys, that's it for this week. I will see you next week, and we'll see how this case ends up. Just like you, I don't know what I'm anticipating. I still don't know what to believe exactly. I have theories. Ultimately, nobody wins in this case.